All right. Venue. Brian, where are we going to bring our lawsuit?
You have choices, and you need to think about what the options are and decide based on strategy, not based on, I'm licensed in venue A, we should just file the lawsuit there.
Absolutely. So you do have choices. The basic venue statute for most cases is 28 U.S.C. 1391E1. And what it says is that if you're suing a U.S. government officer or an agency, then you can bring your case where a defendant resides or a substantial part of the events or omissions giving rise to the claim occurred, or where the plaintiff resides, if there's no real property involved in the case. So those are our three options: where a defendant is, where a plaintiff is, or where the action happened. Right?
It is, but in immigration, just because there's a federal office in your district doesn't mean you can sue them anywhere in the country. There has to be a nexus with the case.
Yeah.
If you just grab a defendant randomly, the judge is going to be irritated. They'll dismiss that defendant out, and then they'll change the venue on you.
Yeah.
They'll transfer it. So I think you need to, again, be careful and think about what is best for your client's case, not what's best for you as the attorney.
Absolutely. It can be tempting to sue where you're licensed, but sometimes that's not where the law is the best.
No, people all used to say, let's just sue in D.C., and there's this nagging, lagging misconception that USCIS is headquartered in D.C. Mm-hmm. That's not been true since 2020. They're headquartered in Maryland, my home state. And the reality is that the judges in Maryland don't want to have 4,000 cases filed in Maryland every year against USCIS. So yeah. I really think you need to focus on where is a plaintiff in the lawsuit located physically, and where is the case being adjudicated, or where was it denied?
Mm-hmm. Right.
Those are the two best options, in my opinion.
There is a little bit of room for jiggering around with venue by tactically adding defendants. You cannot go too far. You cannot just sue the Attorney General on every case to claim venue in DC, right? You cannot take it too far. However, let's say there was a field office involved in deciding your case. You sue the field office director. You can now claim venue there. That is completely legitimate, right? But to get back to what you were saying about USCIS headquarters. So a couple of years ago, USCIS used to be headquartered in DC. I forget when they moved. Was it 2019?
December 2020.
December 2020, they moved to Camp Springs, Maryland, where the USCIS headquarters is now. So before that move, a lot of cases were brought in DC, for better or worse, because basically any lawyer admitted to any state bar can get admitted in DC, so it becomes kind of the default place to sue the government, which has led to bad case law and also, I would say, burnout by judges and U.S. attorneys there, and also a lot of bad decisions. So I think if you talk to experienced litigators, they'll say, try to avoid DC in most cases, yeah. Right? Especially for State Department cases. Do not bring a visa delay case there if you can avoid it.
Delay cases in general, anything less than a 4-year delay now is dead on arrival in DC. Yeah. And this, things will change, but they're not going to change that dramatically. And if you have a business or a family that's sponsoring someone for a green card or immigrant visa, you're probably, even if you think Montana is Republican or Missouri is Republican, there are judges appointed by every administration in almost every district court, and you're going to have random assignment of judges. But I believe in home cooking and home field advantage. I think a judge where someone is living is going to have more interest in hearing out the case than a judge in D.C. who has 9,000 cases.
Absolutely. So after the USCIS headquarters moved, all of a sudden the District of Maryland got flooded with delay lawsuits, over like 160, something like that.
No, just one lawsuit alone, the Chakraborty case was 196 plaintiffs in one case.
Yeah.
They were all Indian and Chinese. They were all employment-based adjustment of status applications. Mm-hmm. So they're all I-45s delayed, and they got a senior judge. He consolidated every single delay case, and what he did was he said these people none of them were Maryland residents. There was no connection to Maryland whatsoever or the USCIS headquarters. So the judge went ahead and severed all 196 plaintiffs, and we can talk about this in our litigation strategy, section later. But the idea was that by bringing one lawsuit with 196 people, you could charge them, maybe $1,000 each, and they might get what they want. But here they didn't. The judge basically split them into 196 separate lawsuits with separate case numbers, and then he sent them to every single district court around the country where people lived.
Right.
And these are all I-45 applicants, so they all had an address. And then that lawyer or the lawyers that agreed to take that case on now had 196 lawsuits to deal with around the country.
Right. So that was called Chakrabarty versus USCIS, right?
Yes.
And then there was a follow-up case called Mann versus Jadoo, Manne, which kind of puts I would say a more, like a little bit more meat on the bones in terms of like the legal considerations with venue, just based on USCIS headquarters. But basically, District of Maryland does not want your delay lawsuits unless your case is at the Baltimore Field Office, or it's at the Administrative Appeals Office.
Or if your client lives in Rockville or Laurel, Maryland, or my hometown of Cumberland, Maryland, if you actually have a spouse, a U.S. citizen who's petitioning for a spouse. So it could be the petitioner, it could be the applicant, it could be the beneficiary.
Yes.
But if you have someone who's a co-plaintiff who has an actual real bona fide residence in Maryland, and a lot of times it's someone's relative, like, the USC spouse is living with her cousin, and then once her husband gets over here, they're going to get a separate address. Right. That's totally fine.
Right. And as far when it comes to adding plaintiffs, sometimes you can jigger with venue through tactical addition of plaintiffs. And so what you're looking for is someone who is arguably within the zone of interests designed to be protected by the statute. So let's say someone is seeking a family-based immigrant visa. The petitioner is definitely within the zone of interests of that benefit. So you can add the petitioner as a plaintiff and sue where the plaintiff resides.
We also had the Munoz case that said U.S. citizens don't have the right to have their spouses in the United States. So there's a question between having a qualified plaintiff, a co-plaintiff, and actually winning on a constitutional claim. They're different levels.
Sure. You're not entitled to have your spouse here, but you are within the zone of interests designed to be protected by the INA when it comes to petitioning for your relative.
And by adding plaintiffs, we want you to do that. We want you to think about that when you're filing a complaint. Yep. Adding them as an amendment is harder later. You're better off really planning out the strategy of your case. And if you have an employer sponsoring someone, employers are often hesitant to file lawsuits, but maybe you can list the employee's name first and the employer's name second.
Right.
There's different ways to try to address it, but the more concrete connection to some things in the district, the better for venue.
Right. So let's talk about venue for some of the more obscure case types. So 8 U.S.C. 1447B, naturalization delay lawsuits, they have their own venue provision in 1447B. It's the district where the naturalization applicant resides.
So that might not be, if you're in Wyoming, you might have to file the lawsuit in Colorado.
Yeah. Well, if you're living in Wyoming?
It depends on which field office would be doing the naturalization, right?
Right, but you have to sue where you reside, according to 1447B.
So you file that lawsuit in Wyoming, okay.
Yeah. Next, FOIA, 5 U.S. Code 552A4B. You sue in the district where the complainant resides, or has his principal place of business, or where the records are, or in D.C.
So you have 4 options, right?
Yeah.
So in those cases, I look at it as being, it's something you want to think about, not the lawsuit stage, but the FOIA filing stage. Is it better to file the FOIA as the lawyer? Would you rather file the FOIA in the client's name? Which has a better venue option? So you really have to assume you're going to have to sue when you're filing the FOIA and plan out from there.
I would not file a FOIA in the lawyer's name now because you cannot get fees. If you file that lawsuit on your own behalf as the lawyer, you can't get fees for that. So I wouldn't structure my FOIAs that way these days. Habeas. Venue for habeas is affected by the immediate custodian rule, or quote-unquote rule, because it's kind of unsettled how it applies in the immigration context. But basically, background, you're supposed to sue the immediate custodian, meaning the person who is the warden of the facility. Now, it creates some weird questions in immigration law when the warden might be a county government official or even a private group like GEO or
a for-profit contractor.
Yeah, a for-profit company that has no power to release the person. However, I typically will sue the ICE field office director that controls the detention. And so if I'm looking for venue, I would need to take that approach. I would need the field office director to be in the district where I'm suing.
Yes.
All right. Now, if you're new at habeas or you don't know how it goes in your jurisdiction, you want to be safe. You want to sue the warden of the facility as well as the ICE field office director, just so you have all your bases covered. Right?
Yeah. Venue is a minimum standard. If you at least get the right person named, you're okay. So naming 3, 4, 5 different defendants is not a problem. You're just spending extra money on the service of process.
Right. One time I named the owner of a private prison, which was a small real estate company, as the immediate custodian. I got a very quick call from some white shoe lawyer saying, "This is terrible for us to be named in lawsuits. We need to substitute out of this."
Good.
Immediately. The U.S. attorney is going to say that the ICE field office director is the person that you're going to sue.
In my prior career as a public defender, I would sue a hospital because they had a mental health unit that kept people. And if I sued them, their lawyer would call me directly and say, "Let's work this out."
Right.
So suing more people might get you more attention.
Yeah. It can also be more work, though, right? So let's say the government disagrees with your choice of venue. They want to move the case somewhere else. So motions to change venue are governed by 2 statutes, 28 U.S.C. 1404A, which says that for the convenience of the parties and the witnesses, or in the interest of justice, the district court may transfer the civil action to any other district in which it could have been brought. So the judge has a lot of flexibility there to transfer cases, as long as the minimum requirements are met for venue. Now, then another statute, 28 U.S.C. 1406A. If venue is laid in the wrong district, then the court can dismiss it, or more often, if it's in the interest of justice, the judge can transfer the case to somewhere else.
Yeah.
So that's a little scary to think that my case could be dismissed just because I filed it in the wrong case, or in the wrong place. However, most often they don't do that.
If it happens, it's a dismissal without prejudice, and you just have to you lose your filing fee, you have to do the work again. But they're not saying that you're going to never be able to bring your claim.
Right. As far as what factors judges look at when deciding whether to transfer venue under these statutes, they look to a set of private interest factors and public interest factors. Those come from a Supreme Court case called Gulf Oil Corporation versus Gilbert, 330 U.S. 501. That's a 1947 decision. So the private interest factors are the relative ease of access to sources of proof, the availability of compulsory process to secure the attendance of witnesses, the cost of attendance for the willing witnesses, and any other practical problem that might make a trial burdensome or difficult.
This gets into the civil idea of forum non-conveniens, and whether or not a trial in one location is easier than a trial in a different location. Immigration is a federal law. Immigration is the USCIS is a federal agency that exists everywhere in the United States. And these cases are usually decided on summary judgment if they get that far. Right. So you're not really talking about shipping records in the 1960s where you had bankers' boxes of deposition records. Though that's still the standard, but the reality is that any district court judge in the country really has the ability to handle these kind of cases, and it's going to be really in the judge's eye what's convenient. And if you have a judge that will let you do things by Zoom and by telephone, you could probably try the case anywhere. But you're going back to those: could the case have been filed in this court originally, and then it's going to be really up to the judge what they feel is going to be the most convenient. So it used to be that people would always say, we still hear it now, that the plaintiff's choice of forum should not be disturbed. I don't know if it was ever true or not, but it's not true, and especially not true in immigration cases.
One thing I've noticed about the government is, you need to be tactical about laying venue because the government is tactical about venue as well.
And they know the circuit court decisions.
Right.
If they want to get a case transferred to D.C., it's because they're going to get a dismissal.
Absolutely. I see this especially in EB-5 delay cases. Normally the message we hear from the U.S. Attorney's Office in D.C. is we are overloaded with cases. Don't file immigration cases here. However, the exception is EB-5. Yeah. If you file EB-5 somewhere else in the country, they will often try and get it transferred to D.C. because they know that your case is going to be dead.
Even if you have a EB-5 investor who lives in Florida, they'll still try to get the judge to transfer the case to D.C.
Oh, really? I haven't seen that when I have someone residing there. Yeah. Okay. So then the public interest factors are the administrative difficulties flowing from court congestion. One time I had a U.S. attorney in Louisiana argue that there's 26,000 cases pending here, so we shouldn't do the case here. The judge said those are actually, most of those cases relate to, I believe, Hurricane Katrina.
Oh, wow.
And they weren't cases that take up a lot of resources. They're streamlined, so that was not relevant.
Mass tort litigation.
Yeah,
sure.
that type of thing. Next, the local interest in having localized interests decided at home. The familiarity of the forum with the law that will govern the case. Federal immigration law, usually there's no advantage anywhere in terms of that. And then the avoidance of unnecessary problems of conflicts of law or in the application of foreign law.
Yeah.
So those are the factors that get looked at if we're doing a motion to change venue. So overall message, think about venue. You have to think about it even when you're doing the consult, because you might need to hire local counsel, and that's going to affect the pricing. So, a client comes to you with a particular issue, you need to have a sense early in the conversation where you're going to file that case and what is it going to take. The client might have to spend an extra $1,000 or $2,000 to hire a local counsel.
Yep. And if you're looking at California versus New York, you have to look at Plan B. If your case does get transferred to the other venue, are you able to do the work for the same price? Is your written fee agreement going to have a clause that says that the client has to pay more if there's a transfer? So you really have to look at all the venue options and have a plan for each of them.
Absolutely. All right, that's venue.